I'll call the meeting to order. And the first order of business is the approval of the minutes from January 25th and February 7th. And Marcus, you had circulated that. Oh, you're on mute, Marcus.
Yes, I believe you know what?
Don't think so.
Okay, you're right. I may not have William. So, uh,
You
that's
can,
on me. That's my fault. I did
um,
not circulate the meeting
if you
minutes in
have them,
advance. Yeah.
Okay.
you can put them up, you can share them, and
Okay.
then go through them that way. You don't have
Sure.
to, pre-distribute or distribute them in advance. It's not a
Do you want
whole
to do
job.
that, Marcus?
Yeah, I'm gonna ask Connie. I mean, do we have the minutes finalized?
I didn't finalize them. I just sent you my meeting notes.
Ah, okay. I think we are not prepared to present the minutes at this meeting then. That's my fault. I apologize. That that just slipped my attention, so I'm gonna have to put it on the for next
Mark
time.
in this, that the approval of the minutes is postponed until
Okay.
next meeting. That should be noted in the minutes for this meeting.
Okay, so we'll postpone that to the next meeting. And then Marcus, you have the mediation and then the data and production report. My understanding, why don't you explain and then?
Yes. I do apologize again for the minutes. That was just my inattention and being very busy, but I will rectify that as soon as possible. The executive director's report on mediation, as well as the caseload report, data and production report. Unfortunately, I was not able to connect to the database, and I'm having some sort of computer connectivity issue. So instead of presenting something that's incomplete, I would ask to defer presenting those two reports until the next scheduled meeting.
Okay, that's fine. Marcus had let me know. I didn't realize it was that you couldn't connect to the database, so you couldn't get the information. Okay, so at the next meeting, you'll have I think it's 3 months probably from
Yeah,
November.
whatever the update is, I'll have it for you folks. Yes.
Yeah. Okay, so that's fine. Thanks, Marcus. So we'll go to the chief counsel's report. Connie.
Yeah, excuse me. There is one thing on the executive director's report that I would like to
Oh, I'm sorry. I'm
raise.
sorry,
Yeah.
Marcus. I see that the request for extension of time to investigate open cases. Please
Yes,
present
correct.
that.
Okay. So I think all of us on the commission side have gone through this process at least once before. And so the commission is requesting an extension of time to investigate its open cases. The last extension granted was, let me see, March 31st, 2023 through March 31st, 2024. And so the extension that we are requesting in this meeting would be from March 31st, 2024 through March 31st, 2025. And that is pursuant to Hawaii Revised Statutes 36813B, as well as Hawaii Administrative Rules 1246-12F.
And that's because the statute requires a certain period of time, a timeline, a deadline to complete the investigation. And there are certain extenuating circumstances that require additional time to complete those investigations. That's correct, right, Marcus?
Correct. Yes.
Okay. So I'll entertain a motion.
Yes, so move.
Okay, second, please. Okay, thanks, John. Any discussion on this? Okay, seeing and hearing none. Anyone object to the extension requested by executive director? Okay, seeing and hearing none, the motion passes. Thanks, Marcus.
Thank you.
Okay, anything else, Marcus?
No, that's it from the executive director side. Thank you.
Okay, perfect, thanks. Okay, Connie. Chief Counsel's report.
Okay, so a quick update on docketed cases. As I mentioned in our last meetings, the parties in the Lansing and Fletcher consolidated cases reached a settlement. And so just last week, the hearings examiner granted the motion to dismiss based on the execution of the agreement. So that's great news. And a second thing is adjudications was notified that the enforcement section sent out a final demand in another case last Thursday. So we might be docketing a new case soon. According to the rules, we have 15 days from the receipt by the respondent, and we haven't got notification that they've received it yet. So it still might be a few weeks out, but by the next commission meeting, we'll probably have more details on that. Okay, next on rulemaking. So I did want to mention or clarify something. So I know in our last meeting, I said I would be sending out dates, hoping to have a public hearing in March. We're probably going to be, unfortunately, have to push that back a little bit. So according to DLIR rules, or not rules, but their policy is to have the AG's office look over our rules and look over our legal notice to hold the public hearing. And so that's kind of where we're stuck. The AG's office wants to take a little bit closer look at the rules. And then they also mentioned that there was a recent Hawaii Supreme Court ruling that came out last year that agency must consider whether the proposed rules during rulemaking impact Native Hawaiian traditional and customary practices. And if so, you have to engage in further analysis. If not, as is the case with our rules, then you just have to have an impact statement, similar to how we had to have an impact statement on small business regulatory issues. So that's just a couple, sticking points that we're looking at right now. So they're going to look a little bit closer, and I know the commission with Robin looked over the proposed rules. So the main sticking point that the AG's office has is on the medical cannabis section. So they're worried that there's going to be a lot of pushback on that section. We've kind of went back and forth on proposed language to the proposed rules, but they feel that if it's substantial enough, we would have to get the governor's reapproval again, and then hold the hearing. So there's a couple options that I think we have. So we could try to just push forward on the proposed rules because there are so many amendments, and just with the thought that we might not change the the section on medical cannabis in the section for reasonable accommodations in employment. So we might just be amending what I think is a little bit more important would be clarification of what is employment, versus independent contractor, and also the pregnancy rules, which changes are now substantively. So it would impact people coming to our office and how we would analyze things. The proposed amendment on the medical cannabis section actually doesn't change our analysis. It just clarifies that if someone tests positive on a drug test at work, the employer should engage in interactive process to see if they do qualify as an individual with a disability and might need a reasonable accommodation. That might not be, a change of policy on drug testing, but it could be a different type of accommodation. They might have to work with their, depending on the job duties and things like that. So it doesn't change our analysis. So I mean, there's, two options. We can just try to do things right, push it back and finally get language that the AG's office will approve, or we could just try to go to hearing, let the AG's office know we probably aren't going to amend that section. That might, assuage their fears of, what, pushback we might get on the medical cannabis section, or we could take a little bit more time. I know we're trying to get to the public hearing before we lose, Joan and Leanne by the end of June. But, those are our two options. The AG's office actually seemed very confident that if we resubmit to the governor with new improved language on the medical cannabis section, that we would be able to hold the public hearing before June. But I mean, that would push us back at least 2 months. So I did just want to discuss that with you guys and see what you feel is probably the best
What is this?
course of action.
What is the change that they want? The
Okay. So I'll share my screen. I can show what is the proposed rules that we've posted to our website, we've received public comment on, and that the AG doesn't like. And then I've been working with them on different language that they haven't quite pushed back on. So, but they haven't said this looks great. So that's also an issue as well. Not sharing the screen yet. Okay. So can everyone see my screen?
yes.
So this is the proposed language that the AG doesn't like. It's under reasonable accommodations for disability discrimination.
So is it F?
Oh yeah, sorry, F. So it's in Ramsay format. So the proposed language is underlined. The current language is just regular.
So it's F that they don't like, and why don't they like it?
They don't like it because they think it's contradictory, it's confusing. It is a little bit confusing. So it does say, it is unlawful for an employer or other covered entity to deny a reasonable accommodation for an employee with a disability who is a registered qualifying cannabis patient, positive for a drug test, unless the patient used, possessed, or is impaired on premises. So they were concerned that there might be situations where it is okay to deny an accommodation, for a disability if there's, safety issues, or if the job duties, require certain compliance with other laws. So they're worried that it guarantees it when it doesn't necessarily mean that they would be allowed to continue with their medical marijuana use. So they just see a lot of inconsistency with this. And I'm not really keen on some of this language too, because I do think case law is going away from like the federal licensing requirements, the Federal Drug-Free Workplace Act. So working with the AG's office, we came up with some other language. I don't know if I can pull this. So this is what an alternative statement might look like. So it's a lot simpler, and I think it actually protects more, and it achieves, I think, what we're aiming to achieve. So again, this is in Ramsay format. This is my Word document, and it talks about what changes must be made, or modifications or adjustments to policies. So it gives those examples, including extended leave, zero tolerance policies, or drug testing policies. So it doesn't mention medical cannabis though, and I think what we were trying to do with the proposed, rule amendments is to explicitly say, if you test positive for marijuana on a drug test, then the employer has to, or the employee has to say, hey, I have this medical marijuana card for a disability, and then that interactive process has to start. But this one is a little bit broader. And, medical marijuana isn't the only drug that might show up on a drug test that someone uses in conjunction with a disability. Someone who has ADHD, they might be taking medication that pops up positive for amphetamines. So this actually would be a little bit broader analysis or broader protection. So this is an alternative to what we have posted on our website. But, the other option is we keep the status quo, we maintain the status quo, and then we keep our analysis the same, HCRC on enforcement side, they will accept, medical marijuana cases. So it's really up to the commissioners. I would be fine either way, but I do think our administrative or our proposed amendments to the pregnancy section and also definition of employment is important to push forward. And I don't think the AG has much issue with those sections.
Okay, so Connie, what is your recommendation, or what are you asking?
If there's any discussion with the commissioners, if they would rather that we, do it step by step as the AG is suggesting, that we, substitute this language and then resubmit to the governor's office for approval to hold the public hearing, which takes, 4 weeks, and then, go through the public notice for the public hearing, or we just let the AG's office know that we are going to keep the status quo most likely, but we're going to the public hearing because the governor did approve having a public hearing on these rules as is.
Okay, do you have a recommendation?
I would like to see these changes, but they're not necessary at this point. I would prefer just to go to public hearing because then we get more comments, on all of the sections that we have proposed amended rules. But the problem with trying to push it forward is the AG's office might not get back to me on their approval or review of our, notice to hold the public hearing, which will delay it further. So my recommendation is to play by the AG's office rules and take what they have commented on and then make those changes to our proposed amendments and then resubmit to the governor's office, which unfortunately would push it back 2 months, but they're really they're the gatekeepers. The AG's office, they have to approve our legal notice. And without their help, we can't do anything really at this point.
We can't go to public hearing.
Right, because
Okay.
they have to review. Yeah.
Okay.
So
Okay.
unfortunately, that's what I would recommend.
Okay. Thanks, Connie. So I was just wondering, is there a way in the revised language to kind of make an indication that we do want to focus on, not focus on, but put in the word cannabis somewhere, medical cannabis?
Drug testing policies, including testing for medical cannabis, right?
Something like that. I think that that's why it was added in before, because it was unclear to employers that
Right.
it is medical cannabis. It can be including but not limited to testing for medical cannabis. But I think it might be helpful to have that, because I don't want it to then we republish this and then our cannabis folks say, what happened to that? Like, but the whole reason why we're doing it is because of medical cannabis, and to be able to protect those folks that, it's a necessity. But I wanted to open it up to the other commissioners if they had any thoughts, questions, or comments.
Maybe it's a bad idea from what I'm now hearing, but I like the idea of just going forward because of the concern that we may not have 2 commissioners if this gets delayed any further. I've seen in other circumstances when there was a rule that it got delayed for a year or 2 or 3, and then I'm looking at some of these now with the Department of Labor and Industrial Relations and some other things in other areas. And the HLRB is a good example of what I couldn't understand how many times I've called and said, what's the deal? Why don't you approve the changes? Some of these things don't make any sense the way they're worded. Now they even refer to the wrong agency name. So, oh, well, we're in a hang up. We're waiting for approval. Okay, so that process That's my concern. I don't want to be in a situation where this comes up at a time period when two of our commissioners are not on the commission anymore. And there's another, go back and, and run this through the commission requirement. So,
Go ahead.
yes, just all. So I'm just worried about if that's a real possibility, if there's going to be a delay to the point, where we're going to be in another circle going back, then I would argue it's better to go forward with what we have and conceivably just leave the other language status quo and take out the new language for that has been proposed and address that later.
Okay, so maybe I misunderstood the process, but Connie, if we were to go forward now, we still wouldn't be able to pass the rules, right? We will. I think I'm a little confused on the process. So what?
Yeah, so if we go forward now, I would have to, I understand what Dr. Pruitt is saying, but I would have to confirm with AG's office that they would approve it with the understanding that we probably won't pass just this section. So it's not a one or all, I think, approval. We can do yes to this proposed change, yes to this one, no to this, and this is all going to be summarized based on the comments that we get and given to the governor. So if we go to public hearing, we can approve some of the amendments, but not all of them, is from what I understand. And it is, based on comments, because maybe everyone really loves this section, so who are we to stop bringing that to the people, right? So.
Okay, so
I can double check with the AG's office to see if they would be fine, if we can kind of assure them that we're not going to change this section of the law, because it really doesn't change our analysis, but we can address it at another time, hopefully when we're not losing our commissioners. And then, that would only delay, a little bit, but they have to get back to me.
Okay. I mean, I don't know how to, Arsima and John, you have any questions or comments?
I'll go along with the recommendation. It makes sense to me.
Yeah, I mean, I would appreciate a better understanding of the process too. Is it like, if we defer, is it like a delay now versus a delay later, because we need AG approval anyway, right? So seems like either way there might be a delay. It's just going to be what gets delayed. Is that correct? Is it the whole package versus a little bit?
Right. And
Okay.
I still have to confirm that if we can assure them, that we don't think this medical, cannabis section will
Would
fly,
they be
then
okay with the rest?
right. Yeah.
Okay.
Would they be okay with the rest? Because they haven't brought up much of any other issues, with other sections. So I think it's a good chance that we could get their approval, at least for the public hearing.
But when it goes to public hearing, the public is going to expect that the rules that we present to them are the rules that we are considering to approve. Now,
Yeah, that's going to be, it would be a caveat to the public. We're presenting it to you in this form, but this form is not going to be the final one, right? They're selling something.
And I mean, so that is part of the, I guess, the process, right? So if there are substantial changes, because after getting a lot of comments during the public hearing, sometimes there are changes to our proposed rules. If there are substantial changes, then you would have to get reapproval for a second public hearing, things like that. But I am not sure if you would need reapproval for a second public hearing if you're just maintaining the status quo either. So I could definitely ask.
You mean taking out do you mean taking out a change?
Yeah, so for this
language?
Case would be just striking, section F.
I mean, my concern is that medical cannabis is kind of it's going to be, people are going to want to talk about it. And so if we presented to the public and they make comments with the understanding that we're gonna take into consideration their comments. But in reality, we tell the AG's office, we're not gonna do anything with this. Seems like we're setting ourselves up for, you know, we're
That's
kind of
true.
misrepresenting ourselves to the public.
Yeah,
Right.
yeah. I think that would make it hard for us. So perhaps then it might be better to just go back with that language that they agreed on with our little change and then just get this done. Just tell them to ask them to rush it.
Expedite.
Right.
Expedite. We sound, yeah.
And you know, the ledge session should be dying down soon, so I think they can. Okay. All right. Sounds good.
You guys okay with that? Are all of you okay with that? Okay. Okay, Connie, that's how we'll go.
So not much to update on legislation. We're just going through hearings. I did list a few of the bills that we are somewhat tracking because they, you know, would impact our agency or that we feel is important. So I don't know if anyone wants to address that, but one additional bill that I think we should comment on is SB 3351, Senate Bill 3351, which is a constitutional amendment to Article 1, Section 5. It's under subsection F. So I'll share my screen again, just so I can pull it up.
So then this language that is being included in the Constitution actually mirrors the language that you have at the HCRC, right?
Slightly. So does everyone see the due process and equal protection?
Yes.
Okay. Yeah, so it just adds in ethnicity, national origin, age, disability, ancestry, or sex. Including sexual orientation, gender identity. So I think it's good. We would recommend supporting this. It, you know, would put a question on the ballot to see if people would support this. I think there is strong support, you know, to expand what bases are enshrined in our Constitution, which is always good. It is interesting. It's pregnancy outcomes as well, you know, so that kind of enshrines protection of reproductive issues.
When we did the support of the other constitutional amendments, did we just supported the bill? Is that what we did?
Yeah.
Okay.
And providing comments because it would have to, you know, the question would have to go to the voters anyways.
Yeah, I would be in favor of supporting and just reiterating the importance of supporting these categories in, you know, enshrining them in the Constitution, but I don't going for a constitutional amendment is always hard. So
Right.
so that you're making a recommendation that we support SB 3351. Okay, do I have a motion?
So moved.
Hey, do I have a second?
No.
No, I can see him now, but I couldn't before. And then is there any discussion? Okay. I wanted to just make a comment. So Connie, when we write the testimony, can we just be clear that as the Hawaii Civil Rights Commission, it is our duty and responsibility and sort of the purview that we protect these classes, and so we do support it for that reason.
Okay.
because that's the position that we're coming at it. I do think that it's just always dicey to put it in the Constitution, though. That's why. But I want it to be clear that
Right.
we do, we clearly want to protect. You guys do it every day, right? Like this is it. All right. I'll put it to a vote unless anyone else has any questions or comments. Okay, I can see everyone. So are there any objections to our support? Okay, seeing and hearing none, the motion passes. Thanks, Connie. Anything
That's
else we need to know about though, Connie? Like any other updates on how anything significant?
not really. So the prohibition, SB 2100 prohibition on credit history was pretty unpopular. It got deferred, so it's probably dead. There's a few of our, the ones that impact us that haven't gotten hearings yet, so we're still just waiting for that. So everything else.
Okay, that sounds good. Anything else in your report?
Nope.
All right. I am pulling up the agenda because I closed it by accident.
Mhm.
Are we setting the next meeting? I think. Yeah. Do you have a proposed, can we do it later in March? Or do you need it to be earlier, Marcus or Connie? And I think spring break. Go ahead.
No, I was gonna say later in March is fine. I think Connie, you're all set with what you need to proceed with the rulemaking, right?
Yeah.
Okay. Yeah, let's see.
Well,
We
Joan
are,
sends her apologies today. So, but she did mention previously that she can't make Tuesdays. So just no Tuesdays.
Okay.
Well, the 26th is Kuhio Day. I don't think we want to go. Right, so
The 28th, maybe? Okay, Arsima,
that
John.
looks fine.
Okay, by me.
Yeah, that's okay.
Okay. So let's do that, the 28th, and then maybe Connie, you can check with Joan if that's okay with her, and maybe, I think we usually do it at 2.
Right. Okay. Do that.
Okay. Are there any announcements?
Well, let's see. We did bring on one new office assistant,
Great.
actually two. One's gonna be starting off 89 day and onto a permanent position. So we actually are having two new office assistants in our office, as well as a new staff attorney.
Oh, a new staff attorney too.
Yes, and so
Great.
we're getting hopefully
More
approaching fully staffed, and we're continuing to recruit for various other positions.
Yeah.
Mm.
Office assistants, that must be hard if you were down to. Well,
Oh, they're crucial for the operation. So yeah, we're very happy to have more people on board.
that's great. Congratulations.
Mhm.
Okay, any other announcements?
Well, I don't have any other. Anyone else?
it's not so much an announcement, but if it's possible, I have something I want to talk to Marcus and Connie about. So you could stay on for a second and let me.
Okay, and
We'll
just
do
don't,
that.
once we adjourn, just make sure we stop the recording. So
Oh
that
yeah,
we-
stop the recording.
and the meeting because yeah, that's your conversation. Okay, thank you so much. Thanks for the meeting. Thanks for your hard work, everyone. And we will see each other at the end of March. Thank you.
Thank you all.
Bye.
Yeah.
Take care.
So.